Hi, everybody. I'm Brittany Lewis with Forbes Breaking News. Joining me now is law professor and former General Counsel to the U.S. House of Representatives, Stan Brand. Professor, thank you so much for joining me.
Good morning.
The Minnesota Supreme Court recently rejected the 14th Amendment argument that would have barred former President Donald Trump from appearing on the state's primary ballot in 2024. So can we back up here? Can we start from the beginning? And can you explain this 14th Amendment argument?
Yes, this was passed after the Civil War when the Congress decided that as part of the bevy of constitutional protections and extensions of rights that were put into the Constitution, they were going to bar former Confederate loyalists and others, participants in the Civil War, from holding federal office. And so they passed this as part of the 14th Amendment, Section 3. And although it was subject to what's called an Amnesty Act in 1872, when the Congress decided in its wisdom to lift it, it's remained as part of the Constitution. And so now it has resurfaced as part of the dispute over former President Trump's actions post-election in 2020.
So let's talk about present day now. How solid of legal ground was this recent filing?
The Minnesota Supreme Court decision was really a procedural decision on what we lawyers call ripeness. And essentially what the court said was that it's not time for us to decide this, because the primary system in Minnesota, as it is in most states, is really under the control of the political parties. And so until that process plays out and the party actually has a nominee, it's not timely to decide whether the 14th Amendment bars placing him on the ballot in Minnesota.
The Chief Justice did say this petition could be brought up once again in the general election. So what's the likelihood of this being rejected again or, passing?
Well, the problem is that there are a host of definitional problems in the 14th Amendment itself. One is the definition of what is an insurrection. I mean, there is an Insurrection Act, which is a very complicated and in some sense vague statute or series of statutes that defines a rebellion or domestic violence. Secondly, the amendment provides that the person subject to it has to have engaged in insurrection or rebellion. That's another interpretive minefield. And then lastly, there are a series of questions about whether the amendment even applies to the president, since it defines officer of the United States in a specific way that is not consistent with other provisions in the Constitution. So it's not even clear that by its terms it would apply here. And then there are a bunch of other issues, which are, does this have to be adjudicated before it could be applied, or is it, in the words of former appellate judge Michael Ludig, self-executing? And so it's really a hornet's nest of interpretive questions. And the last one, of course, is presidential elections are 50 state elections. So the question would be, what happens if one state or two states prevent the former president from being on the ballot and other states allow it? And that would skew the Electoral College, obviously, and raise a host of questions about whether anybody could obtain a majority of the Electoral College as specified in the Constitution. So it's a real, it's a law school exam type question for which we have no answers.
That sounds tough. A law school exam, a hornet's nest of interpretive questions, as you just said, that really paints a very descriptive picture. So did the Trump team use this to their advantage? Can you describe what their defense looked like here?
Sure. Their defense, I'm not sure their defense here raised all of those issues, but they certainly raised some of them. And there are cases pending in other states. There's a case in Colorado which recently concluded in a 5-day trial with witness testimony and documentary evidence, with the district judge, the lower court judge, stating that she would rule by the beginning of the month, which would then be subject to the Supreme Court of Colorado's review. And then ultimately, I think the real decider about all this would be the Supreme Court of the United States, where if a state were to make a final decision on this, not a preliminary one like was issued in Minnesota, my guess is it would get to the Supreme Court in some fashion, and I would guess they would take that case.
Let's talk about those cases in both Colorado and Michigan, talking about the eligibility of Trump on the ballot. Do you think that they are going to have similar outcomes here, because we just saw Minnesota be thrown out, or do you think it will be different?
Well, one issue I suppose would be I don't know the Colorado law on whether the political parties are deemed, in a sense, to control the decision of who gets on the ballot. I didn't see any of that talked about during the trial, and so I'm not sure how that would play in Colorado. In Michigan, the Secretary of State of Michigan has already said that there are certain Michigan state law provisions that tie her hands in who she can decide to put on the ballot. So as a matter of state law, I think she's taken the position that she doesn't have any authority to keep anyone off the ballot, and that will have to be a decision by a state court, presumably the highest state court in Michigan, to decide.
Were you surprised that this petition in Minnesota was rejected, or do you think that this was always a long shot?
I think it was always a long shot, and just to bring in the sensibility that courts have and the rules that govern their acceptance of cases are cabined by a bunch of doctrines that restrict what courts can and cannot decide. So at the federal level, the Article 3 judicial power is limited to actual cases or controversies. And what the court has used that to do is duck, if you will, or decline to exercise jurisdiction in cases where the case isn't ripe, or the party hasn't been concretely injured, or it's what is known as a political question. And I think this question partakes in some or all of those issues. And so the courts, and even state courts, mirroring what the Supreme Court does in these cases, is reluctant to step in until the process plays out in some way in the political branches. And by the political branches, I mean the legislature and the executive. So there's a reluctance to decide unless it's absolutely necessary.
Former President Trump really took a victory lap after this decision came out, and he posted this on Truth Social, his social media platform. He called the lawsuit ridiculous and also without merit and unconstitutional. What do you make of his assessment here? Was this unconstitutional?
Well, not yet. The court didn't rule on the merits. The court said, we're not going to get to this now. And so the merits have been preserved for a future time. But it is in a general sense a victory, because there's no adverse judgment against his being on the ballot at this point.
As we know, he was indicted 4 times in this calendar year alone. He recently testified in a New York fraud case, and there have been investigations and lawsuits swirling around him. Do you see any of his other legal issues being a hindrance for him for 2024? Because as we know, he's far and away the front runner in the presidential race in the Republican Party.
Well, from a legal and constitutional standpoint, the short answer is no. The Constitution doesn't bar indicted or convicted people from running for president or being elected. The standing qualifications for office for president, as specified in the Constitution, are that he be 35 years old, a natural-born citizen, and a resident of the United States for the last 14 years. In fact, the state of California passed a law that attempted to put a prescription in the law that would say if you don't provide your tax returns publicly as a candidate, you can't get on the ballot. That was stricken down. In history, Mayor J. Michael Curley of Boston served as mayor after he was convicted and incarcerated. Now, being mayor of Boston isn't being president, but the question of whether any of this has a bearing on his eligibility for office, there's no textual basis for that.
Do you think then, let's take it away from Trump, but do you think it sets any sort of precedent for any future presidential contender? Because he has made history as being the first former president to be indicted 4 times. Or do you think Trump is just a special case here?
Well, my own view is we have been on a slide on a slippery slope since Watergate. And we have institutionalized and regularized application of the criminal law to the president. And going all the way back to Nixon, when Special Prosecutor Leon Jaworski determined that he could but wouldn't indict President Nixon, up to and including President Bill Clinton during the Starr investigation, this has always been a looming question. And now it's been presented front and center. And what has happened historically, unfortunately, in my view, is we are stepping closer and closer and closer to the abyss in terms of using the criminal law as a very blunt instrument in prosecuting a president. And what is, if past is prologue, we're not going to go back from that. The one thing I know is that we've never retreated from the post-Watergate, quote, reforms, where we put all of this criminal process into play. So he may be the first, but my view is he won't be the last.
That's really interesting because you're using terms like close to the abyss. Is this the point of no return? Have we reached that, do you think?
Yeah, I think it's unfortunate. I think now look, in my other life, I'm a criminal defense lawyer, so you understand where my biases might be. The Supreme Court has struck down a series of criminal cases against public officials where very broad general criminal statutes have been used to prosecute governors, members of Congress, and senators. And they've thrown cold water on these cases because they've said basically not every single corrupt act, deceitful act, tawdry act, these are the words the court used, are crimes. Whether that's the governor of Virginia or a aide to Governor Christie in the Bridgegate scandal or a host of other cases. And so the use of these very broad and general statutes to go after someone for what they claim are, frauds against the United States in the general election and the post-election period, I think is a quantum extension of the criminal law to something that wasn't envisioned as a proper use of prosecutorial discretion.
And what do you think is missing then from the national conversation? You are a law expert, so what do you think are the gaps here?
Well, the gaps here are, if you listen to some of the popular media, it's all about whether Trump will be convicted. It's all about the strength of the case. It's all about the things that happened post-election. No one is talking about in depth or informing the public about the complicated legal issues that underlie the situation that we're in. And we've seen this. We saw this when the former chief of staff filed a removal petition from state court in Georgia to federal court. We're going to see this in Washington. The president's lawyers, the former president's lawyers, have filed a motion to dismiss, claiming that much of what he did on January 6th and thereafter were privileged acts within the, quote, outer perimeter of his line of duties. That's going to have to be decided pre-trial, I think. And so what everyone is looking to the legal system for is a quick and decisive answer to all of this. And based on my 50 years of litigating in this sphere, there's going to be nothing quick or decisive about it. It is going to drag on conceivably, even if he is convicted of any of these cases, well past 2024, because that's the normal pace of this type of litigation, and we're already seeing that.
In your eyes, in your view, what do you think is the most complicated legal issue not being talked about, A, and B, why is there nothing going to be quick and decisive about this?
Well, I'll take the last question first. The judicial system is a deliberative, slow-moving, thorough system in which the devil is in the detail. And courts want to hear the full range of legal argument. They want to consider it, and then it takes them time to decide. And then there are levels of appellate review that further thwart a quick and easy solution. So you have a district court opinion, then a court of appeals decision, then conceivably an en banc or full court of appeals decision. Then you have stay motions to the Supreme Court and merit decisions in the Supreme Court. This is the design of the judicial system. It's not designed for slapdash answers. It's designed for due process and deliberative consideration of, in some instances, novel legal questions.
And people's eyes glaze over once you start, listing out what needs to be done here. They want the answer ASAP. And what do you think is the most complicated legal issue not being talked about right now when it comes to this?
Well, there's a host of them. I think the one in the District of Columbia in federal court is, can you apply the general conspiracy statutes to these actions? To say nothing of what's now, at least in the Court of Appeals through Trump's lawyers, which is, what restrictions does the First Amendment put on a gag order on a political candidate in the middle of a campaign who is maintaining that he is free to talk to his supporters about issues in the case that are intertwined with his candidacy, and that's going to be a very interesting and complicated case. And then to the merits of that case, as I said, can these general conspiracy statutes and general prosecutorial theories applying them be adjudicated and used in this case to obtain a conviction? And then, of course, there's the case in Florida where the Classified Information Procedures Act has severely complicated the case. And that's a statute that tries to balance the right of the government to maintain its classified information against the defendant's right to obtain it and use it as part of his defense. So these are all really difficult questions.
Professor, as we've stated this entire conversation, we are really in unprecedented waters. So I really appreciate your expertise today, coming on in and breaking it down. Professor Stan Brand, thank you so much for joining me.
My pleasure.